Mr. Speaker, I am pleased to table in this Honorable House the bill entitled the Criminal Code Amendment Non-Consensual Sharing of Intimate Images Act 2021. This bill introduces criminal offenses and penalties relating to the non-consensual sharing or threat of sharing intimate images and prohibited visual recordings, as well as the offenses of observing or making recordings in breach of a person's privacy. Mr. Speaker, in our 21st century world, a new form of technology-facilitated abuse has emerged that is commonly known as revenge porn. Revenge porn typically occurs when someone shares or makes threats to share intimate images of a person without the person's consent. Increasingly, intimate images are being recorded and stored on our smartphones. This means that in an instant, an intimate image can be uploaded to a social media platform, forwarded or broadcast at the swipe of a finger with little concern about the long-standing consequences or harm to the person captured in the image. In no time at all, an intimate image uploaded to the internet can trend or become viral in an instant and is exceedingly difficult to remove permanently from the internet. Sadly, Mr. Speaker, weaponizing intimate images created under the trusting sanctity of a romantic relationship can be used as a tool to inflict revenge when the relationship breaks down. Even though the intimate images may have been obtained in a consensual context, the parties are unlikely to have consented for the intimate images to be shared with third parties outside the relationship. Oftentimes, the associated threats may be to distribute the intimate images to a specific person or persons to cause the maximum harm to the recorded person. Intimate images can also be distributed without any forewarning threats. Mr. Speaker, in today's digital world, non-consensual distribution of intimate images can take the simple form of images sent to friends and family of the recorded person. The end result being to expose, humiliate, embarrass, or cause reputational damage to the recorded person. Undoubtedly, the stress and trauma imposed on the victims to such acts and their families can be far-reaching. In the gravest cases, affected persons have contemplated, attempted, or committed suicide because of the associated distress and embarrassment. In some circumstances, the threat to distribute intimate images is intended to cause alarm to other affected individuals, not only harm to the person recorded in the intimate image. Whatever the likely or intended harm, once intimate images have been shared digitally without consent, it is difficult or impossible to contain them from spreading like wildfire. Mr. Speaker, although minimal protections exist addressing the distribution of obscene or indecent images under the provisions of the Telecommunications Act 1986, there is a glaring gap in the existing law because the prevailing offenses do not sufficiently address intimate images and prohibited visual recordings within the context of revenge porn. There are also no criminal provisions in the existing law that deal specifically with the threat to distribute such images. We have surveyed other jurisdictions, including Canada, the UK, and Australia, that have each introduced specific criminal offenses prohibiting the non-consensual distribution or threatened distribution of intimate images. Canada's and Queensland, Australia's approach to such offenses were considered in detail in formulating the policy. Accordingly, Queensland's approach is primarily modeled in the bill being tabled today, as their criminal code amendments were considered most appropriate for Bermuda. Queensland's criminal law prohibits the distribution without consent of an intimate image of another person in a manner that will cause distress reasonably arising in all of the circumstances. The legislative wording is adopted in this bill. Mr. Speaker, you've heard me use the terms intimate image and prohibited visual recording. These two terms are germane to the legislative interpretation of the proposed amendments to the Criminal Code Act 1907 and are defined in the bill. The term intimate image includes intimate images that have been digitally altered. Digital alteration can be done to an image to depict intimate sexual activity or private body parts, and digital alteration can also apply when intimate sexual activity or private body parts are obscured if the person in the image is still depicted in a sexual way. The term prohibited visual recording is also defined in the bill to deal with circumstances where the recording is made in circumstances where a reasonable doubt would expect to be afforded privacy. Mr. Speaker, the relevant offenses proposed within the bill for inclusion in the Criminal Code Act 1907 are observations or recordings in breach of privacy, distributing intimate images, distributing prohibited visual recordings, and threats to distribute intimate images or prohibited visual recordings. Mr. Speaker, to operate as an appropriate deterrent and to ensure the seriousness of the offenses is understood by the public, the penalties for all offenses are up to 3 years on summary conviction and up to 5 years on indictment. Mr. Speaker, the victims of the crimes being created are likely to want to have a remedy in law that can help stop the distribution of the offending images and have them deleted altogether. In this regard, provisions are made in the bill to allow the court to make a rectification order ordering the removal, retraction, recovery, deletion, or destruction of any offending images after a successful prosecution. In closing, Mr. Speaker, this bill deals only with the criminal aspects of this issue. It achieves this by creating relevant offenses and proportionate penalties, ensuring that offenders can be successfully prosecuted and dissuading offending behavior. It is important to note that the criminal law alone is sometimes a harsh instrument to address contemporary social issues. Deterring the offending behavior and effective punishment must also be augmented with a more holistic societal approach encompassing civil law remedies, public awareness campaigns, education, and other community-wide efforts to raise awareness about the associated dangers of recording intimate images. Individually and collectively, we have a responsibility to be vigilant and discerning about our conduct in digital and online spaces. The assistance of the wider community is paramount to protecting our youth, especially as they navigate their maturation in a digital social media age. It is anticipated, Mr. Speaker, that this new law will directly protect victims of revenge porn and others whose privacy will be violated by misuse of intimate images and private recordings. It will indirectly protect societal values by upholding privacy and personal protections from the irreparable harm that such violations inevitably impose on others. Mr. Speaker, I'd like to thank the Deputy CPC, Lorraine Welch, the Director of Public Prosecutions, and Lawyer and Policy Analyst Jason Otteridge for their excellent work on this very important initiative. Thank you, Mr. Speaker.